Welcome back to this third part of land law easements, and we are carrying on, of course, with looking at the ways that an easement may be created. We have, of course, looked at the express ways in which an easement may be created, and just by way of brief recap, you can certainly have an easement by way of an express easement in a deed or expressly in a written contract. Now we're moving on into areas where an easement is created by implication. Now, let's just get a basic understanding of what this actually means. What we will be looking at here are easements where the parties have not necessarily between them made an express declaration as to there being an easement in respect of the two pieces of land. Rather, what we have is the court implying that there is an easement based on the circumstances. Now, this implication, of course, is read back into the deed. Now, again, this may be a little bit difficult to grasp, but the point is, when you look at the implied grant of an easement, necessity or mutual intention, say, what the court looks at is that there must have been a deed in order for the parties to then imply that there was an easement back into that deed. Because if there was not a deed used to convey the land, you will of course not be able to get certainly the implied grant of necessity and the implied grant by mutual intention. Now, if you are looking at an exam question with easements, one of the things to consider is that examiners speak for a deed is if the examiner tells you that the property has been conveyed, or if the words say that in the conveyance, or the conveyance did not expressly grant or reserve an easement, that suggests that you certainly are looking at an easement, certainly looking at a deed being used in this regard, and the easement will then be read back in the deed. So let's continue then. The next way of acquiring an easement is certainly an implied grant by necessity. What that means is that if you sell me a piece of land, but I must cross your land in order to get to the main road, there may be an easement by necessity that I'm able to acquire. Now, if I do, it becomes a legal easement. But it sounds easier than it really is, because the reality is that for an implied grant of an easement by necessity, the courts say that it must be absolute necessity. And the general approach is that you're looking at, for example, landlocked to land. So let's say, for example, Mr. X, who owned Blackacre, sold me Whiteacre, which he also owned. However, Whiteacre is completely landlocked. I cannot get to the main road but by walking through Blackacre. If that is the case and I'm the owner of Whiteacre, the court will say that an easement of necessity arguably has been acquired by me. That type of easement amounts to a legal easement. And as I say, the courts will imply an easement of necessity in the conveyance. Now, necessity, the cases say, means absolute necessity. And the cases to look at for these, of course, are Titchmarsh and Royston Water and Menzies and Breadalbane, because there was an alternative route in Menzies, and that prevented the creation of an easement of necessity. The way this manifests itself in exam questions, for example, is if the examiner says to you that A sold Whiteacre to B, and there is a patch of land, or the examiner says to you that there is a side gate that B could use to get to the main road, but unfortunately it's full of brambles and rocks, that's irrelevant. You cannot acquire it unless it is absolute necessity. Indeed, in Nickerson and Barclough, the Court of Appeal said that easements of necessity would not be created simply because it was public policy that land should not be landlocked. So if, for example, I have been sold landlocked land, But the fact is that I had gotten it at a premium, so extremely cheaply. The courts may suggest that certainly I had paid for what I got. And so just because it is landlocked, again, will not mean that I will get an easement of necessity. Examine the exam question closely to see whether or not you are able to suggest that a party has acquired by necessity. So look at the circumstances of the case and decide whether an easement was actually implied between the parties but hadn't been spelt out in the deed of sale. There always needs to be a deed in order to claim an easement of necessity, and the easement of necessity is then implied into the deed. Now then, let's consider an implied grant of mutual intention. If that is the case, that makes it a legal easement. So if you can acquire an implied grant of an easement by mutual intention between the parties, the court says that it will also be read back into the deed, and as such, it would certainly be a legal easement. Here, the courts give effect to what they think the intention was between the parties when the land was sold. So when you look at the case of Wong and Bowman Property Trust Limited in 1976, the court said that as between the parties, it would appear that there was an agreement that certainly they would have allowed, or there was an agreement as such that they would have allowed the extractor to go straight through to the upstairs property rather than outside. Now, if there is no deed between the person claiming the easement and the person whose land the right is over, there can be no implied easement of mutual intention. There must be a deed for that to occur. But that said, the court will look at the parties' intention, and if the courts are of the view that the parties appear to have agreed in a particular manner that there was to have been, for example, a right of way, the courts will imply that back into the deed, and it will be a legal easement. The next one, of course, is an implied grant under the rule in Whelan and Burroughs. An implied grant under Whelan and Burroughs can be legal or it can be equitable. Now, I want to just pause on this for a moment and examine Whelan and Burroughs, because in Whelan and Burroughs, the court laid the framework whereby a party who has land and certainly, for example, has been using that land in a manner where the right being claimed, the property owner was using the right in that manner. Remember, I said earlier that you cannot acquire an easement over your own property. But if you were doing something on the land which amounted to a quasi-easement, then it may very well be that under the Whelan and Burroughs framework, it may very well be that an easement is acquired. Now, here under Whelan and Burroughs, you may be able to acquire a legal easement or an equitable easement. It simply depends on what the examiner tells you, because Whelan and Burroughs operate whether or not a deed was used. So if a deed was used to sell the property, you can get an acquisition under Whelan and Burroughs. If a written contract was used to sell the property, you can also get it under Whelan and Burroughs. So what you tend to find is that by and large, exam questions do tend to focus largely, when you consider easements, the two areas heavily tested are Whelan and Burroughs type easements and Section 62 of the Law of Property Act type easements, which we will come to shortly. But first, let's explore what the principles are in Whelan and Burroughs. Well, in Whelan and Burroughs, the rule is that if there is a right that you're seeking to claim, then the right must be continuous and apparent, and it must be necessary for the reasonable enjoyment of the land sold, and also that the right you're seeking to claim was in use both previously and at the time of the sale for the benefit of the part of the land sold. Now, What does this mean? Well, it simply means this, that, as I said to you before, you cannot have an easement over your own land. But let's assume that I own an acre of land. And let's assume that the eastern part of the land is on the border with the main road. But the western part of the land is backed onto land or other open field. Let's assume that I decide to sell off the eastern half. So I sell half acre, which is the eastern half, and I retain the servient land. So I retain the eastern part and I sell off the western part. Let's get that clear. I sell off the western part and I retain the eastern part. The eastern part is close to the road. Now, if I sell the land to B and he gets the western part and he still needs to walk over to the eastern part to get to the main road, then remember that it was my land. I didn't need an easement. But if I had been using the land to walk over the land to get to the main road, then that quasi easement, that path that I would have been using from the end of the western part through to the eastern part, the courts will consider it a quasi easement. Now, if it is that I have used a deed to sell the land, then the rule in Wilden and Burroughs says that because it was continuous and apparent, and it was necessary for the reasonable enjoyment, and the necessity here is different from the implied necessity, because all that it is necessary for is for the reasonable enjoyment of the land sold. So there could be another way for me to get to the main road. But if it was that it was being used before, and at the time of the sale it was being used, then the law says that under the rule in Wilden and Burroughs, I will be able to acquire an easement. What you need to carefully watch, though, is whether the examiner says to you that A sold B the land or whether A conveyed the land to B, because that makes a huge difference, because conveyance tends to suggest that a deed was used. After the break, we will consider the whole implication of a grant under Section 62, and also, of course, we will look at prescription and how, in fact, you can protect an easement.